Thank you very much for this insightful presentation. Really interesting. Our next speaker is Milos Vukotic from the University of Belgrade, Serbia. He will speak on civil law and the transition to socialism, court practice after the abrogation of civil legislation in Socialist Yugoslavia. And Milos has finished his undergraduate studies at the University of Belgrade, Faculty of Law, in 2014, and currently studying for a master's course in comparative legal tradition at the same faculty, and working as a teaching assistant for comparative legal tradition since 2014. Thank you.
So, hello everyone. I decided to write about this, the fate of civil law in socialist Yugoslavia, because I think it fits perfectly with the subject of this conference. And as you will see, the socialist revolution in Yugoslavia, this transition to socialism, was largely different from the stark communism in the Soviet bloc. And this makes the question about civil law, the continued application of civil law in a socialist society, very, very interesting. I would like to begin, of course, by a very brief historical introduction. As all of you know, during the Second World War, the Kingdom of Yugoslavia experienced a socialist revolution. The Communist Party, which organized partisan forces that liberated the country, abolished the kingdom in November of 1945, and the new constitution of the Socialist Federal Republic of Yugoslavia was enacted in January 1946. That same year, in October, the People's Assembly, the main legislative body of Socialist Yugoslavia, passed an act of unprecedented significance for one legal system. This was an act which abolished all previous legislation of the Kingdom of Yugoslavia. It abolished all the laws that were in all the parts of the former Kingdom of Yugoslavia. This act was called, as you can see, the Act on the Invalidity of Legal Acts Enacted before 6th of April 1941, the date when Germany invaded Yugoslavia, and during the enemy occupation, obviously referring to the period when Yugoslavia was occupied by Axis forces. Although this, I will call this enactment the Invalidity Act because it's much easier. So the Invalidity Act abolished all previous legislation, but it did not really do away with the whole legal system that existed before the war. In fact, it enabled the pre-war legislation and the old law to continue to be applied in everyday for everyday situations, not only by courts but also by other public bodies. So the Invalidity Act enabled the continued application under two conditions. So a court or any other public body could apply individual rules from the abrogated laws. So the laws that were abrogated could not be applied. They could not be cited as the basis for any decision. But individual rules could be applied on the basis of this Invalidity Act. And in fact, in the decades that followed, we actually accepted a completely new technical term, old legal rules. And in Serbia and in other former Yugoslav republics, when people refer to old legal rules, they usually mean old legal rules in the sense of the Invalidity Act, the old legal rules that could still be applied in socialist Yugoslavia. The most interesting question, of course, is what is the legal status of these old legal rules? So all the previous legislation is abrogated, the laws have lost their legal effect, and yet public bodies and courts can still apply some rules, some provisions from these abrogated laws. The Article 4, the most important article of the Invalidity Act, states, as you can see, that old legal rules can, under this act, be applied to relations that are not regulated by legal acts that are in force. And from the wording of this provision, we could conclude that the courts had the discretionary power to choose whether they wanted to apply old legal rules or not. However, a different attitude was accepted in legal theory because it was understood that any functioning state needs a body of law to resolve everyday disputes. So in legal theory, it was accepted that courts do not only have a power to apply old legal rules, but that the courts must look for, that they have a duty to look for adequate old rules and to apply them. Of course, when these conditions of the Invalidity Act are fulfilled, and that is that all legal rules are in conformity with the principles of the new socialist society and in conformity with the new law. So we come to a very interesting situation. Rules from abrogated laws were applied as if they were law that is in force, but with a general legal standard that allowed the courts to judge whether some old rules are still in line with the new socialist principles, which is a very, if you think about it, a very unique situation for any continental legal system, which is based which is primarily based on the civil codes and other statutes. However, this structure was acknowledged by the decision of the Supreme Court of Yugoslavia in 1951, in which the court specifically stated that the courts are under a duty to look for adequate old legal rules, and that the courts cannot even decline to the application of these rules on the basis of a general assumption that the rules are not conforming to the new socialist principles. In fact, the Supreme Court stated that if a court wants to avoid an old legal rule that is applicable to a given situation, it needs to do this in a reasoned decision, and it needs to specifically state why an old legal rule would be in contradiction with the new law. So what you have with this court decision is actually a presumption in favor of the applicability of old legal rules, although the legislation was already formally abolished, although it formally lost legal effect. And here I would like to, so we can conclude that, of course, according to a very doctrinal legal analysis, when applying all legal rules, the courts would actually be applying the Invalidity Act, given that all laws have lost legal effect. And this is what Professor Konstantinovic, one of the most famous Yugoslav civilians, said about all legal rules. And I think this sums up the legal status of all rules quite accurately. So he said, the so-called legal rules, this was a new term, are not hard rules of the law, but a much softer material, which is given to the judge so that he can use it the best he can in order to fill the gaps that were created by global abrogation of legal force of all previous legal acts. But in fact, we cannot even speak about legal gaps in socialist Yugoslavia, given that the whole legal system was abolished. Actually, the courts very often had to rely on these old legal rules, and in practice, we almost had a continued life of the old legislation, although it was formally abolished. But this application of old rules was further complicated by the fact that Yugoslavia did not have a unitary legal system. To give you an example in civil law, the Austrian civil code was applied in regions of today Croatia, but even there you had a difference. the old version of the code was applied in Croatia and Slavonia, whereas the new version of the Austrian Civil Code was applied in Dalmatia and in Slovenia. On the other hand, you also had Austrian Civil Code in Bosnia, but the situation was complicated by the fact that personal and family matters of Muslims were governed by Sharia law. In Serbia and Macedonia, you had the Serbian Civil Code, and then Montenegro had its own civil code, whereas the region of Vojvodina was largely governed by Hungarian customary law. So these are all the different civil codes and different rules that were applied in the Kingdom of Yugoslavia. So then the question naturally arose, what if there are two or more old legal rules that can be applied in the new socialist state? How can the courts choose between different rules? According to one approach, the old legal rules should be applied territorially, as they were applied before the abrogation of previous legislation. However, this approach was quickly abandoned because it was clearly seen that it would only perpetuate the legal particularism and the legal divide in new Yugoslavia. This traditional approach of territorial application gave way to a very interesting new approach that courts are actually free to choose the most adequate legal rule if they can choose between several adequate old rules. And this judicial freedom was accepted in legal theory and in court practice as a way, of course, to overcome legal particularism and to make some sort of new socialist civil law that is acceptable and adequate for all the parts of the new country. And of course, such judicial freedom is completely unprecedented in a continental legal system, as Serbia and Yugoslavia was. This scope of judicial freedom was confirmed in another decision of the Supreme Court in 1956, which dealt with the right to compensation for pain and suffering. So the second instance court denied the right to compensation for pain and suffering, saying that the Montenegrin Civil Code, which was in force in the territory where this case took place, that the old Montenegrin Civil Code does not allow compensation in this case. However, the Supreme Court reversed both decisions and stated that given that old laws are abolished, the courts are not bound by them, but they can choose the most adequate old legal rule from all the legal rules that were in effect in the Kingdom of Yugoslavia. But not only that, in fact, the court stated that courts are even under a duty to invent an adequate solution if a solution cannot be found in the old law. And basically, this decision gave the courts the right to invent law if they couldn't find any applicable old rule. This judicial freedom was crucial for the development of civil law in Yugoslavia after the war. But this was done in an indirect way because, as you all know, in a continental legal system, judicial decisions do not have the power of precedent. So the importance of the innovations that were introduced in the legal practice was that they served as models in drafting of the new legislation. So we have new legal developments entering in individual court decisions, and then these court decisions were relied on to create the new legislation. I would just like to give you some examples of how this judicial freedom shaped the civil law system of Yugoslavia. For instance, the most important new introduction to Yugoslav civil law was the introduction of strict liability for dangerous objects and dangerous activities, given that strict liability did not exist in pre-war legislation. And it was also important that the courts removed outdated rules such as rules that instituted inequality between the sexes, or which gave binding power to betrothal and the duty to give dowry and so on. But what is interesting, apart from these innovations and apart from these departures from the old law, in most cases, especially in the law of obligations, the courts continued to apply the old legal rules as if nothing had changed in the new socialist settings. Because, if you, in contrast with the Soviet Union, as we have just heard, the courts in socialist Yugoslavia continued to exist, almost there were not so many changes in the way that the courts functioned and in the structure of the courts, and of course all the judges had to be educated lawyers. So that there was a continuity of legal education and a continuity of the legal tradition. And some of these old legal rules are still applied today, which is very interesting. And here is the important instance of the Serbian Civil Code. The Serbian Civil Code from 1844 is still applied in Serbia for the contract of gift, for the contract of partnership, and for treasure trove. The case where someone finds buried treasure on his property. So I would like to conclude by saying that in these revolutionary times, in this transition to socialism, we can clearly see the conservative nature of the law, and we can clearly see that it was actually completely impossible for the new government to completely break the legal tradition and to create a new socialist legal system. In fact, the courts still relied on the legal tradition, on traditional legal education, and on traditional doctrine. And many traditional rules of civil law survived to inform the new socialist law, and this is most notably the case in the Code of Obligations of Yugoslavia. However, I must say at the end that the impact of socialism was mixed. Some areas of the law were more changed. For instance, labor law, company law, they were completely devastated. But the crucial central points of civil law, such as the law of obligations, remained largely intact. Thank you very much for your attention.